Lord Legate will explain the court's judgment.
This appeal raises a question about the extent of diplomatic immunity. Diplomatic immunity is governed by terms of an international convention, the 1961 Vienna Convention on Diplomatic Relations, incorporated into UK national law by an Act of Parliament. Under the terms of the convention, diplomats are completely immune from criminal proceedings in the receiving state, that is, the state to which they're sent as part of their country's diplomatic mission. They are also generally immune from civil claims. There are, however, certain limited exceptions. One of these is for civil claims relating to, quote, any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official functions. The dispute in this case is about the scope of that exception. The claimant, Miss Josephine Wong, is a national of the Philippines who worked as a domestic worker in the household of Mr Khalid Basfar, a diplomat representing the Kingdom of Saudi Arabia in the United Kingdom. Miss Wong claims that she was trafficked to the UK by Mr Basfar and his family and forced to work for them in their home here in conditions of modern slavery. She alleges that she was confined at all times to Mr Basfar's house and was only allowed to go outside to take out the rubbish, that she was held virtually incommunicado and was only allowed to speak to her family twice a year using Mr Basfar's mobile phone, that she was made to work from 7 in the morning until around 7:30 at night every day with no days off or rest breaks, and that she was subjected to further degrading and offensive treatment. Ms Wong claims that after arriving in the UK, she was paid nothing for 7 months. She was then paid some money in Saudi Arabian currency, which was a fraction of her contractual entitlement, and after that, she was not paid anything for a further 10 months, at which point she managed to escape from Mr Basfar's household. Ms Wong has brought a claim against Mr Basfar in an employment tribunal, claiming wages and compensation for breaches of employment rights. Mr Basfar applied to have the claim struck out on the ground that he has diplomatic immunity from suit. He has not admitted any of the facts alleged by Ms Wong, and there has been no hearing to decide whether her allegations are true. Mr Basfar argues that there is no need for such a hearing because, even if the allegations are proved, the claim against him must be dismissed because he has immunity. To test that argument, it's necessary to assume that the facts alleged are true and ask whether, on that assumption, Mr Basfar has immunity. This depends on whether his alleged exploitation of Miss Wong constitutes a commercial activity exercised by him, falling within the exception to diplomatic immunity that I've mentioned. The Employment Tribunal rejected Mr Basfar's application to strike out the claim. The Employment Appeal Tribunal reversed that decision, but certified that the case was suitable for an appeal directly to the Supreme Court, leapfrogging the Court of Appeal. The Supreme Court then granted permission for this appeal. By a majority of 3-2, the Supreme Court allows the appeal and decides that on the assumed facts, Mr Basfar does not have diplomatic immunity in relation to Ms Wong's claim. Lord Briggs and myself, Lord Legate, give a joint judgment with which Lord Stevens agrees and which is therefore the majority judgment, giving our reasons for that conclusion. Lord Hamblin and Lady Rose give a joint dissenting judgment. All the members of the court agree that the ordinary employment of a domestic worker by a diplomat does not involve the exercise of a commercial activity within the meaning of the exception. The majority do not think that this follows just from consideration of the words used. As a matter of language, purchasing goods and services, including hiring a domestic worker, could be described as exercising a commercial activity. But in interpreting the terms of the diplomatic convention, it is necessary to consider not only the ordinary meaning of the words used, but also the purpose of its provisions. As explained in one of the recitals to the Convention, the purpose of diplomatic immunity is to ensure the efficient performance of the functions of diplomatic missions as representing states. It would impede the ability of diplomatic missions to perform those functions efficiently if diplomats and their families were at risk of being arrested or prosecuted in the criminal courts or sued in the civil courts of the receiving state. The exception for civil claims relating to the exercise of commercial activities needs to be seen alongside another provision of the Diplomatic Convention, which forbids a diplomatic agent from practicing for personal profit any professional or commercial activity in the receiving state. It would be contrary to the purpose of giving diplomats immunity to interpret the exception for exercising any commercial activity as including activities incidental to the daily life of a diplomat in the receiving state, such as purchasing goods and services for personal use. The ordinary employment of a domestic worker is not, on this logic, to be regarded as a commercial activity that falls within the exception. However, the majority of us do not consider that the same is true of the trafficking and exploitation of a domestic worker. Exploiting a domestic worker by compelling her to work in conditions of modern slavery is not comparable to an ordinary employment relationship that is incidental to the daily life of a diplomat. There is a material and qualitative difference between the two activities. Employment is a voluntary relationship entered into freely and governed by the terms of a contract, whereas the essence of modern slavery is that work is extracted by coercing and controlling a victim. The extent of control over Ms Wong's person and dominion over her labour exercised by Mr Basfar on the assumed facts of this case was so extensive and coercive as to place her in a position of domestic servitude. Further, on the assumed facts, Mr Basfar gained a substantial financial benefit by deliberately and systematically exploiting Ms Wong's labour for almost 2 years, initially for a fraction of her contractual entitlement to wages, and later for no pay at all. In the view of the majority, this conduct is accurately described as a commercial activity practised for personal profit. It amounts to the exercise of a commercial activity by Mr Basfar outside his official functions. In our judgment, Lord Briggs and I consider what the appropriate criteria are for distinguishing between, on the one hand, ordinary domestic employment arrangements that are incidental to the daily life of a diplomat in the receiving state and are covered by immunity, and, on the other hand, exploitation of a domestic worker for profit which falls within the exception for commercial activities and so is not covered by immunity. We express the view that the relevant criteria are provided by the concepts of servitude, forced labour and human trafficking, which are recognised in international law and are now often grouped together under the description modern slavery. On the assumed facts, this case falls within all these categories and is a paradigm example of domestic servitude. For reasons to which I cannot do justice in this very short summary, Lord Hamblin and Lady Rose dissent. They do not consider that a distinction can be drawn for this purpose between employment of a domestic worker and exploitation involving trafficking, forced labour or servitude. In their view, the conditions under which a person is employed or how she came to be employed cannot convert an employment relationship into a commercial activity that falls within the exception from diplomatic immunity. By a majority, then, the Court decides that on the assumed facts, Mr Basfar does not have diplomatic immunity in relation to Ms Wong's claim. Unless admissions are made, a hearing will therefore be needed in the Employment Tribunal to determine the truth of her allegations.
The Court is now adjourned.